left to right, we have, thank you, Kelly. Couldn't remember. Kelly Devine, Jason Dennis, Andre Hayes, Darshell Pierce is not present at the moment. I'm Dennis Matthews. We also have our board solicitor as well as representation from the municipality. A couple quick items before we get started this evening. If anybody is here for application 12-26, the subject property is 1733 Willow Street. That application has been continued, as well as application 33-26. Subject property is 39 East Jacoby Street. That application has also been continued. So we will not be hearing those applications this evening. With that said, we'll jump into the first application. It's 53-25. The applicant is Marcel Yanez, 515 Plymouth Road, Suite P7, Plymouth Meeting, PA. The subject property is 705 Chain Street, Norristown, PA. The property owner is New Star Homes, LLC, of 64 Coral Drive South, Phoenixville, PA. The applicant is seeking a variance from section 320-41, use regulations to permit the use of a duplex in the R2 residential district. Just a note, Ms. Pierce is present.
Also, Mr. Chairman, we attempted to amend this application to the applicant being New Star Homes. The applicant name we currently are using is just an employee, I believe, of New Star Homes. So we're going to amend this application. Any objection, Mr. Campbell?
No, thank you. Good evening. Charles Campbell for the applicant. This case was previously heard in part, was continued after they were adjourned in the course of the last hearing to allow my client to gather additional evidence regarding some questions the board had raised, or members of the board had raised, about the cost of converting this property to other uses other than its present configuration, which is a quadruplex. So it's on. Did you get all that or no? Okay, I'm sorry. So we have additional evidence as to the cost of number one, rehabbing this property to make it useful as a quadruplex, which is its current configuration. A second estimate for the cost to change it from a quadruplex to a triplex, which would consist of 2 units in the main building and 1 unit on the side building, which is separated from a brick wall from the main building, and the smaller building being on the corner of Chain and I believe it was Oak. And a third estimate showing the cost to make the main building a single-family home. We have a witness the witness who created those estimates is present. We'd like to have him sworn and have him give testimony as Mr. Julius Demetrius. He also has some familiarity with the building itself, having done heating, ventilation, and air conditioning work on it for going back at least 15 years. So I'd like to call the witness and as well as the representative of New Star Homes.
Vijay Pitambaram. V-I-J-A-Y P-E-E T as in Tony H-A-M B-A-R-A-M. Julius C. Demetrius J-U-L-I-U-S C D-E-M-E-T-R-I-U-S 1 day.
You both sound square or wrote testimony about the truth, the whole truth, nothing but the truth.
Mr. Demetrius, where do you reside?
Scott Street, Coltmont, PA.
Sir, can you get closer to the microphone?
751 Scott Street, Coltmont, PA, and I also have an office at 933 West Main Street, Norristown.
What is your occupation?
I'm a general contractor, HVAC and plumbing. General contractor, HVAC and plumbing, and electrical.
Are you licensed to practice your occupation in the municipality of Norristown?
Yes, sir.
And how long have you been so licensed?
Since Norristown's been carrying license, I guess the past 3 years. Since Norristown's been starting their license about 3-4 years now here. But I've been licensed here for almost 25 years.
Were you asked to examine the property at 705 Chain Street in connection with this zoning application?
Yes, I went through the whole place, yes.
Prior to being asked to do that, did you have any familiarity with this building?
I worked on this building 15, 20 years ago. Before there was a candy shop on the left-hand side. And prior to that, there's always been 3 apartments.
Okay. Where were the 3 apartments that you're referring to?
Well, the corner property would be the candy shop, and then the 3 other properties would be 1 to the left and 2 on the right-hand side upstairs. There's been 4 electric meters there, 4 gas meters there, for as long as I've known.
Do you remember who your client was that had you do work there 15, 20 years ago?
No.
Are you certain, at the time you did the work, was it operating as a quadruplex?
Yes, it was.
Was the corner
Don't-
piece a residence when you worked on it, or was it something else, because you referred to it as a candy store?
15 years ago, it was a candy store. I don't know. I never went into the apartment. Did service downstairs in the basement. That was it.
And when you did this work, how many meters, electric meters were there?
There's always been 4 meters.
And are there 4 there now?
Still 4.
What's the present condition of the property? Is it occupied?
No, no one lives there.
Do you know when it was last occupied?
The fire last about a year ago when I was called out that night.
Who called you out?
I represented his company when I was there,
You're referring to the applicant.
the applicant.
What did you do?
Coordinated with Lynn Bixler about closing up the property, boarding it up. Closing up the property, boarding it up, and made sure all people were exited the building. Then we sealed it up. Has been open since.
The present application is for a variance to convert the property, the main building, to a duplex, and the corner property to remain as an independent building, dwelling. Do you understand that?
Yes, I do.
Did you prepare estimates of the cost of, number 1, restoring the property to an operating quadruplex, number 2, to convert the property to a triplex with 2 units in the main building and 1 on the corner, and lastly, the cost of making the main building a single-family home and the corner property to remain as a separate building.
Yes, I did.
All right, I'm going to ask that these exhibits be marked.
Continue from the last hearing, that would be A5. A5?
A5? Are they the same as these, except they're signed?
More detail, that is not. So we can use this. We
How
can
many
use
copies do you have?
7 copies, 7 each.
Yeah, my copy. Here's 8.
71. I think it's written as 4 units.
Where's the one with 4 units?
This is for 4 units.
says 4 to 3.
These are all to do as 4 units as it is. This is 10. This is for 2 units, this is for 3 units. We can do one by one.
It says 4 units to 3.
This is 4. Just do as it is. So this is the lowest amount.
I don't know what you're giving me. I can't use this.
Use that one.
Should I mark them all or just mark one? Okay, A5 is the estimate to restore property to quadruplex. Oh, how many did I see? A6 is the estimate to convert from the quadruplex to a triplex, 2 units being in the main building and 1 on the corner. Wait, actually, let me take that one. A6 is to convert. And A7 is to convert the main building to a single-family home with the side building remaining as a separate dwelling, or a duplex in full. And just so there's no ambiguity, I believe the application asks for relief in the form of a duplex. By doing so, my client's intent was to request relief for a duplex in the main building with the side building being a separate third unit.
So the request is for a triplex, because it's one lot, right?
One lot, one parcel.
So 2 units in the main building and 1 in the side building.
Yes.
And if I may add, it has 2 physical addresses. Even though parcel is 1, the address comes as 701 Chain Street and 705 Chain Street. The first corner building or corner property, they call 701. The middle one is 705.
There was some testimony in the prior hearing that the buildings are separated by a brick wall.
Yes.
That-
Yes.
You've been in the building, Mr. Demetrius?
Yes, it
Is that
is.
true?
Yep.
Thank you.
Okay, so Mr. Demetrius, I'm going to show you A5. Did you prepare A5? Did you prepare A5, A6, and A7?
Yes, I did, every one of them.
What does A5, what is A5?
A5 should be just going to a single unit, if I'm correct.
To redo.
All applies to all 4 units. This is my first estimate I gave him. This is converting the whole entire building.
That's to keep it as
For
4?
4 units, yes.
Which is its current configuration, correct?
Correct.
And what did you estimate the cost to be to restore the building to working order as a quadruplex?
51,200.
And can you explain generally what work is needed to restore the property to a functioning quadruplex?
Basically, it's a couple windows, certification of fire escape, needs hardwiring smokes. Hardwire smokes. And that's basically that. Couple repairs on water heaters, upgrade the air conditioning, stuff like that. Because right now the heaters are just, we're gonna give them central air and stuff like that on top of the units right now. Right now it's just warm air. Warm air. All right.
Now, I was going to show you A6. And it says at the top, convert 4 units to 3 units, is that correct?
Yeah, basically, I would take, I called it the candy shop. Candy shop, I called it a candy shop, and what I would do is basically, cut the wall opening, get an engineer to cut a lintel in, and make that open come into that room and turn that into at least a 2-bedroom duplex downstairs, 2 apartments. So instead of 1 single room, we make it 2. It's big enough to make 3, actually. But that's something else we have to design and go for approval. Pulling out the gas heaters, because you don't want to have 1 heater to heat 3 different heaters to heat 3 different sections of the property, so I'm going to revamp the whole mechanical of the property. Also change the water lines due to the water heaters. You have 4 different water heaters, you got to tie everything back in and make sure everything ties back into the right apartments.
Okay, I will now show you A7. What is A7?
Just turn this into 2 units. Basically, you're ripping all the ductwork out, upstairs, down, 4 units, taking them all completely out. Changes to 2 water heaters, 2 gas furnaces. We run ductwork from the basement all the way up to the 3rd floor.
Okay, and what was your estimated cost to,
About $122,000.
and that would make the main building a single home, and the second building would be the corner, is that correct?
Yes.
All right, and turning back to A6, what was your estimate of the cost of making
Should
the
be-
building 3?
Should be like $72,500,
So there's approximately
$50,000.
$50,000 difference between extra cost to make it a single-family home, correct?
Correct.
Why does it cost so much more to make it a single-family home?
You got kitchens that rip out, you have walls that change, you have steps that have to be added. It's just a lot more work. It's too much work for a property this size. There was a stairwell, and it was there years ago, was taken out, so you gotta add another stairwell, bring it up to the 3rd floor, if you're gonna split it into a duplex.
Do you have any knowledge whether the use of the property as a quadruplex was lawful or unlawful when it was operated as such?
I do not know.
Are you aware of any action taken by the municipality of Norristown to affirmatively discontinue the use of the property as a quadruplex?
As of last week, yes. Last week. That's when I started doing my estimates.
Okay. I mean, in the past,
No.
okay, I have no further questions of the witness. And I move position of A5 through A7.
Any cross for the witness?
And may it please the board, Finn Scovedale, Skovdal, representing the municipality of Norristown. And I'll get close just so we can
That's
be on the
fine.
mic. And sir, you stated that you've worked with this property many years.
Many years I've been called for service calls
Okay.
throughout the years.
How many years was that?
Over 20.
Over 20. And I believe you testified, and correct me if I'm wrong, I apologize, but last year this property was occupied?
Last year, this property was occupied when the fire resulted of, I think they plugged in an electric heater. Okay, the last year, the property was occupied. The fire was caused by an electric heater plugged in an outlet, and the cord caught on fire. And this is where it all started.
And were those tenants of the property?
Yes, there was.
And you stated earlier that the property is separated by brick walls. Are you referring to brick walls between 707 and 705? Or another?
705 and 701, yes. There's one brick wall separating it, yes.
Have you, and no is an okay answer, but have you reviewed county records for this property in your?
No.
I have no more questions.
Thank you. Any other witnesses, Mr. Campbell?
No, I have additional documents.
Sorry if I sit down now?
It's okay if the witness sits, takes a seat? County designation of the property's use as of its last countywide appraisal. Next is A9, which is the tax claim bureau records showing no balance due on taxes for this property, the taxes being paid on the basis that it is in fact a quadruplex. A10, which is a these should have been stapled, I apologize. So a two-page document, which was a index page provided to me by the municipality's council, which accompanied a production of documents that were supposed to be provided at the last hearing. They were provided to me shortly after the last hearing, or at least some documents were. This index was on top of those documents.
So this list represents the list of documents that you received?
No, it represents a list of documents that I ostensibly was receiving, but I'm going to then introduce A11 to show a communication I had with municipalities' council requesting the production of documents that were described in that index that I didn't receive. And just so I guess I'll make this point, which is, if I may, this is kind of argument, but I want council to know why I'm introducing these documents in case he wants to respond. The index sheet that I received, as you'll see in A10, first page, states that Norristown in 2008 listed this property as a quad. I didn't receive a document that Norristown listed the property as a quad. I do have through my own efforts, not through what I received from the municipality, that a 2008 county listing had the property listed as a quad, and you have that, I just introduced that. So I did, in this email marked as A11, asked for that document that was described in that index. I have not received it, so I can't produce it. I'm going to ask the board to infer that there is a document where the municipality did list this property as a quad, because there are no documents earlier than 2008 which indicate whether or not this property was lawfully used as a quadruplex. So the question, it's configured that way. Whether it was ever lawfully made that way, I think the reference to Norristown listing it as a quad in 2008 is evidence that the municipality did so authorize it.
Mr. Campbell, sorry, quickly. A10, can you tell me again what A10 represents?
Following one of the hearings, this may have been, you may have heard this twice before, I'm really not sure. And there's been some continuances as well, but Ms. Williams from Mr. Kilkenny's office was present at one of them, and there was a request that the municipality produce its file. I think the board also asked for that information as well because of some lack of clarity about how this property was authorized to be used in the past. So there was a continuance, and then I eventually received a 250-page approximate stack of documents from Mr. Kilkenny's office with that index on it. And I went through the stack of papers, and it was essentially all code violations, which there are a lot for this property. I don't know if that's necessarily a matter for this case, but there were a lot. But there were no records. The records did not match up to what that index said was there. So I don't have the 2008 document referencing that the property was listed as a quad by the municipality.
And you're saying the municipality represented this as an index to?
Yes, that was
they
on
provided?
the top of the doc. I picked them up at Mr. Kilkenny's office and from his receptionist, and that was what was there. So I'm going to ask that there was I'm going to ask for an inference that there wasn't, at least the borough regarded it, the municipality regarded it in 2008 as a quadruplex. The county certainly did. And the tax payments were made on that basis, but it was a quad.
But you're saying none of the documents here were provided as part of that package except for a stack of code violations?
Well, let's see, I identified in the email A11 what to Ms. Williams what I did get. Approximately 250 pages of photographs of the property depicting the conditions leading to code violations, citations, and warnings. So there were a lot of photos showing graffiti and basically a dilapidated property with weeds, numerous warnings to the owner of code violations, and there were citations as well. But I didn't get that document that I think is important for decisions in this case. So I would ask that those additional documents be admitted and made part of the record as well. I did at 5 o'clock get some documents from the municipality's council with some historical records. I forget your name, I'm sorry. Scoville? Mr. Scoville did, I think he's going to offer a couple of those documents. They aren't the documents I was seeking, but I will introduce them and make whatever he tell you what he wants you to make of them, but I don't think the documents that were sent to me at 5 o'clock included any documents from 2008 or anything earlier than 2018 with regard to this property. So with that, I think that's all the evidence I wanted to introduce.
Thank you. Does the board have any questions for the applicant or his witnesses?
So, to clarify, the application is for what? Because it says, I know here it says duplex. You presented some evidence that suggests that it was originally a quadruplex. I heard some evidence, there's some evidence introduced for a triplex. What are we actually going for here?
We're asking for a triplex consisting of 2 units in the main building, the 705 building, for lack of a better description, and the 1-story building on the corner to be a separate dwelling, so it'd be 3 dwellings in total, triplex.
Okay, so the duplex, and if you could just help refresh me, what would be the configuration of the one property has the 2 units, what would be the configuration of those units? And the other property, which is the single unit, which all makes the triplex, what would be the configuration of that? I apologize if this has been covered before.
No, I may not have been, so do you want to address that? Do you understand the question?
Yeah.
Well, keep your voice up, okay?
Yeah.
Speak slowly.
So there are, as we said, it's one single parcel and there are 2 buildings side by side, and there are 2 physical mailing addresses, 701 Chain Street and 705 Chain Street. Currently they are configured as 701 is single unit, 705, first floor is 1 unit, second floor another unit, third floor is another unit. So initial submission was we submitted for duplex, and then because it's configured and it has meet all the requirements, it has a fire escape, so then we requested to modify that request to make it as 4plex, because with 4plex we're not changing anything, we are using the building as it is, it's just that we need to repair whatever the current repairs are. That's why we gave 3 proposals to say, I think that was one of the requests that came up. In case if you were to rehab that as it is, what would it cost? So because we are not going to make any changes, but if you make any more changes to make it 4plex to triplex or duplex, so then we are trying to converge the electrical meters. That means we are going to remove the existing electric and do new electric the way it is, and then we are going to mix the 4 gas meters to less meters so that connection properly supports the heating system and cooking. So that's why the cost goes up as we reduce the number of units, because we are going to remove something and we have to redo electrical, plumbing, gas, kitchen and all that. So our request is to, because it was previously used as 4plex and currently configured as 4, and we have 4 water meters, so 4 heaters, 4 gas meters, 4 electrical meters, and that's how it is. And in the counter record says there are 4 units. So based on that, we would request, to approve for 4, and with that we'll do what needs to be done to pay for any prior licensing, and we'll get the township permits as needed. We will do what is expected by the board and the municipality.
So that seems to contradict what your counsel just said. Your counsel indicated that you were your proposal is for a triplex. So you're saying that your proposal is actually for a quadruplex. So that's what I'm trying to get some
there is some
on.
small confusion. The reason the confusion is that because 701 logically not physically separated with a brick wall, so we are treating 701 as it is a separate building, even though they are in the same parcel. And so what council is requesting is triplex for the middle building, which makes it 3 + 1 total 4.
Okay. So what is the configuration of these units?
So the first,
Bedrooms, baths, so forth and so on?
all are 1 bedroom, one bath.
All one bedroom, one bath
Correct.
units? And the unit that has the three, they're all each on a separate floor?
Correct.
Okay. And then the separate parcel, or the separate unit, that's one single floor, one bedroom, one bath,
It is studio. It is studio.
a studio?
Yeah.
Okay. All right.
All right, and just so we're clear, that was not what I had outlined for the board, so if my client now wants the board to consider that, I would just ask you to do that as an alternative request, but that was not the request I outlined in my statement. And that may not have been the evidence in the prior hearing either, so.
I have questions for this young man.
Come on.
Go ahead.
All right, so to my understanding, you said you first worked on this house 20 years ago, is that right?
Pretty much 20 years ago.
20 years ago was 2006, correct?
Correct.
In 2006, when you, now we're going back in time, but when you observed the property, what did you notice about the property that was, I guess, let me rephrase my question. So in 2008, it says that the county listed this as a quad. So you were there 2 years prior to that.
Correct.
When you visited the property in 2006, can you please describe to me what you saw?
Well, the candy store was a unit by itself. That's outside on the left-hand side. That'd be the 701. It's a brick building by itself, but it was attached to, I would say, 703 and 705. 705?
You
Yeah.
can talk to him when he's.
Okay, 705. And you can walk into the place, go up the steps. Each floor it was 2 apartments. If you go into the left-hand side, through the hallway, you can go to the other apartment on the first floor, all by itself.
Did it look like the home was modified prior to you visiting it?
The only thing modified in that place was the floors, upgraded the kitchens, cabinets. That's really it. Some of the original heaters are still there when I was there. They're probably 15, 16 years old, 2 of them.
It was 2 original heaters.
Yeah.
So when you see 2 original heaters, what does that indicate?
One was in one apartment, one was in another apartment.
So in 2006, you visited the property and you saw 2 heaters, which indicates that it would be a duplex. Is that correct?
No, it was a triplex at that time. I never had a service call on the 3rd floor, so I never had to go up that way.
You testified earlier that there were 4 heaters.
There is now, because I was in there.
There is now. But in
Yes.
2006, you just said there were 2 heaters, correct?
No. I only worked on 2 heaters in 2006. I didn't say anything about the 3rd or 4th floor. Didn't say anything about those heaters upstairs. I wasn't up there for them.
I'm sorry?
I wasn't upstairs for those heaters in that time.
Where are the heaters located in the structure?
One is in the basement, one's in a closet on the 2nd floor. It's basically right off the kitchen.
Okay, so you worked on the house. What type of work did you do on the home in 2006?
HVAC and plumbing.
So in your professional experience, you only noticed a house that could maintain 2 heater units or 4 heater units?
There's 4 heater units and there's 4 gas lines.
There were 4 gas lines in 2006?
I say 2000, I would have to say yes. Can't be positive, can't remember the gas meters, but I know I seen them this past week.
So you're unsure whether or not there were 4?
Correct.
So the work that you did to unit 1 and 2? That's what you claim?
Bad flame rod on one, maybe a bad blower motor on number 2. I would have to go back in my records and really pull them up. I just remember the property being there.
So, so you gave an estimate here for a quadruplex, a triplex, and a duplex.
Yeah, 52,000, 72,000, 122.
When you went to give an estimate on the work that you did in 2006, what did you, what estimate did you use then? Did you look at the entire property, or you just looked at fixed units?
Just that one unit, or maybe at that time.
Is
Just
that,
service calls, that's all they were.
is that what the client requested you do, or is that what you gave as your professional opinion, that only one needed to be fixed?
That's all I had to do is to be fixed. It broke down in the middle of winter, I go there and fix it.
Okay, did you pull any permits or any requests from the county at the time that you did the work in
I
2006?
had no permits to be pulled when you're fixing a heater, sir. None.
Did you do any research on the property prior to you going there and doing any work on it?
No.
So Exhibit A7 and A6, you have included in your quote electrical and building work, but it's not in your quote for
I'm good.
A5. Why is that?
Repeat that one again, that last part?
Sure. Exhibit A5,
Okay.
A6, and A7, you outline you break down what your quote entails, yes?
Correct.
Okay. So, in Exhibit 6 and 7, you included electrical and building work. However, those aren't listed in A5. Why is that?
Because 4 units are already done. Everything's in place already.
So, what's in place at this time? What are you referring to that's?
Okay, A4, excuse me, whatever number you guys are, but the 4 units right now have 4 different heaters, 4 gas meters, 4 electric meters. No work has to be rendered. 4 water heaters, no work has to be rendered. Then you go to the 3 units. Then you have to pull one of the meters out, cut it, pull the wet, rewire it back to another panel, and then you have to tie it back into that panel. Well, that panel's gonna have to be upgraded to a 200 amp service, which we have to drop another line down because the load calculation is gonna change on this building now, since from 1970 to now, it's now changing. Okay, you can't just put a 100 amp unit and have central wear, gas stove, electric stove, washer, dryer. It all calls about load calculations. Each unit has a different load calculation. When you start changing things, you have to do reconfigurations of everything.
Was that load calculation done in 2006 as well?
No, I didn't install it, sir. I wasn't part of it. I was just there for service. I fixed a gas heater. I remember the property.
Thank you.
Board have any other questions? Do you have any
Spouting?
questions?
Questions for that witness? No additional for that witness, but I have additional witnesses when.
Do you have any objection to the exhibits?
No objections to the exhibits.
So we'll admit the exhibits and then present your case.
Thank you. And just for some clarity for the board, applicant's Exhibit A10, I do have the author of that document present. It's Mr. Keith Gordon, in case the board has any questions pertaining to that document. And if I may, for time, for the board's time and for the public's time, if I can give a quick offer of proof of what Mr. Gordon would testify to. He would testify to that he has done research on this property, and I will have him testify briefly, but he's done research on this property that through the county. And this property is one parcel. There is no 701 or 703 addresses. That might be from the post office, but that's not from the county. There's no separate parcels within this particular property. It is one property at 705. We are not denying at some point the county and possibly the municipality had listed this or called this a quadruplex. We can see that there are 4 gas lines within that property. But this property appears to be originally constructed as a twin. You can see on the Google pictures, it's 2 distinct properties side by side attached with the brick wall in between from 705, our property that we're discussing, and 707 is the next property. As to some of I think there was some discussion that documents were not provided, and testimony that an email was sent by me today at 5. I did receive some additional documents at 5 and immediately sent to council. And those documents, which I will be introducing, some of these documents, which would be a UNO from 2018 and a UNO from 2020. So if I may have Keith Gordon testify.
State employee for legal.
Keith Gordon, Gordon.
You sound square or testimony about the case, or the truth, the whole truth, and nothing but the truth.
I do.
And Keith, what's your occupation?
I'm the manager in Norristown Building and Code Department. Been employed here for 11 years.
And do you have some familiarity with 705 Chain Street?
Yes.
All right. What is your familiarity?
So, starting back in 2020, I conducted a property transfer for that location.
And I'm holding you a document in front of you. Would that be part of that property transfer?
Yes, it is.
And can you explain what that is?
This is the zoning determination on that property that shows that the use of a single-family dwelling was permitted in this property at that time.
And what was that date?
That would be May 22, 2020.
And Mr. Solicitor, were there previous exhibits submitted by the municipality?
I don't have any, so we'll mark them P1, P2. The zoning determination, you want to mark that as P1? Or and go from there?
Yeah, I'll mark this as P1. Thank you. And Mr. Gordon, can you further explain that packet that I marked as P1? I guess the process for UNO.
Yes, when there's a, excuse me, anytime there's a property transfer, property owners have to obtain a zoning approval before we will conduct the property transfer.
And just for the record, that the zoning approval for that property was for single family.
That's correct.
And this property was transferred on May 29th of 2020, is that correct?
That's correct. A property transfer was filed for this property by the buyer as required by the code, and the buyer applied for a property transfer for a single-family dwelling only.
And to your knowledge, the applicant that was present was the same buyer that acquired the property in 2020?
Correct.
And Mr. Gordon, I'm holding in front of you another document. Do you know what that is?
This is also a zoning permit issued in January of 2018 for this address, 705 Chain Street.
And do you see a applicant on top of that?
Here, yes, I do.
And to your knowledge, is that the prior owner of this property?
That's correct.
And what was the determination of that zoning letter?
This was for the proposed transfer of a 4-unit residential property in accordance with the ordinance. And, excuse me. and that's what it was for. So you see it doesn't,
And was
it
that,
says it's denied.
and just for clarity, that transfer was for a 4-unit property was denied?
Correct.
And what was the date of that?
That was January 24th, 2018.
I'm marking this as P2. And Mr. Gordon, you said you are familiar with this property?
Yes,
And you heard the testimony of the HVAC contractor that testified today?
correct.
And you heard him testify that the space was occupied a year ago?
I did hear that, yes.
To your knowledge, have any rental licenses been obtained for this property?
To my knowledge, there hasn't been no rental license since 2019, and no legal occupancy of this property's been approved.
And starting with 2019, can you give the board a quick rundown of the history of the property?
So, sure. In 2019, the property was vacant. In 2020, through my investigation, I learned that a quad was denied and was only approved for a single-family dwelling. And as I stated earlier, the previous buyer had applied for the UNO, which was approved for a single-family dwelling only. Also, during September 2020, that property was still vacant, and it caused the municipality to have to come in and board it up. All right. In 2020, they applied for a property transfer for the vacant property, which was a complete rehab, and they only did some work with some windows and stuff. So,
Was the property still boarded up at that time?
yes, it was. Like I say, it's never been legally occupied. We obviously had occasions where people were found to be living in there, and they were subsequently removed each time they were found.
And is the property currently boarded up?
Yes, it is.
Now, what's the condition of the property, to your knowledge, at this time?
I would say it's in condition where it needs some work. It's boarded up. No one's living there.
And are there any active violations on this property?
Yes, there is. There's quite a few. Actually, Mr. Campbell was speaking about a packet he received earlier from us, and he thought some were missing. This is not a list of documents. This is just a list of chronological events I put together. This is the packet that Mr. Campbell received. These are all the violations and notices that were issued for this property.
And for purposes of time, we won't go through all the violations, but are there any outstanding fines for those violations?
Yes, about $1,500 worth.
And is there anything else owed on the property, to your knowledge,
Um,
besides those fines?
no.
In terms of the addresses of 701 and 703, did you do any investigation to those?
Yes, I did. I researched the municipal records and the county records, and there is no such address of 701 or 703 under the parcel. The only parcel that exists is 705. It's one building, one parcel. That's all it is. I wasn't around long enough to know if there was a candy store there. That may have been. That happens a lot of times. People open a little store like that. The post office may have given it what they call a convenience address, so they have somewhere to deliver separate mail to. But as far as we're concerned, and the county is concerned, it's one parcel, 705.
And do you know, last question, do you know if the previous owner had applied for zoning relief from the zoning hearing board
The previous owner,
in 2018.
I think the only one I saw was for a single-family dwelling on that previous document you presented.
Okay. I have no more questions.
Mr. Campbell?
Thank you. Mr. Gordon, the two zoning actions that were documented in Exhibits P1 and P2 were all in response to requests by the prior owner, is that correct?
Yes,
The person who sold the property to my client, correct?
correct.
The first one was a request for approval for a quadruplex that was denied, correct?
2018?
In 2018?
I'd have to look at it again, but I believe that's correct, yes.
And in 2020, there was a request for a use and occupancy permit for a single-family dwelling, correct?
Correct.
And that was around the same time the property was transferred to my client, correct?
Within weeks, that determination was dated.
Have you ever seen this property configured as a single-family home?
I have never been inside the building. When I did my property transfer, that was in such disrepair that it was unsafe to enter that property.
Okay. Do you have any knowledge that my client consented to the persons who were made to leave, that he had consented to their occupancy of the building?
Yes, he was aware they were there.
Okay. And how do you know that?
I spoke to him on the phone.
Okay.
When we found those people there, told him we needed to have them removed.
All right, that's all I have. Thank you.
Thank you. Board have any questions for the municipality?
I just have a quick question for Mr. Gordon in reference to A10, which is this index, proposed, I guess, index that was on top of the documents that were delivered to council.
Yes.
And there was some question about one of the line items saying that this was listed as a quad, both by the county and Norristown. You made some reference to that this is not a list of documents in there. Can you clarify how do you like reconcile this with what was sent to council?
I don't know what right to know request they filed, what documents they asked for. This is a list of items I found during my investigation. So what documents they asked for and they received for the right to know. Why they didn't get them from 2008, I can't answer that. I don't know.
Okay. Thank you.
You testified that, to your knowledge, there were no rental licenses from 2020 to present day. Is that correct?
Yes,
You did mention something about a rental license being available or showing a rental in 2019. What was that for?
no, I testified that I have no knowledge of a rental license since 2019. There was none. I have no information that there was ever a rental license issued for this property since I've been in contact with it.
You also testified that, according to the county, this property is listed as a single family. Is that correct?
I don't ever remember saying a single family. It was listed as a single family through zoning for the municipality.
What is it listed under the county as, to your knowledge?
It depends on the dates you look at it, but most of the information I found from the county listed it as a quad.
And the county listed it as a quad since 2008? Is that correct?
The information, yes, that I found, 2008, 2011, I found another listing from the county for a quad, yes.
How is it that the county is listing it as a quad, but the municipality is listing it as a single family? Where does that error come in at?
Well, I don't know that that's an error. The county don't update their records. I don't control the zoning and planning department. They're the ones that are responsible for listing a property, whether it should be a quad or a triplex or a single. That's not the building department's job.
You stated that in May of 2022, it was listed, I'm sorry, you show a record of it being a single family. But about a week later, it was sold or transferred. And you said that transfer was also done as a single family?
Yes, there was a zoning approval that denied the quad and listed it as a single-family dwelling. And then when the previous owner applied, like a week later for his property transfer, he applied for a property transfer for a single-family dwelling, not a quad or a triplex or a duplex.
To your knowledge, at any time, did the municipality recognize this structure as a quadruplex?
So my records show that in 2018, it was listed as a quad.
And that's the county records or municipality
A
records?
municipality record, sir.
And what happened that it went from you said, what year was that? I'm sorry?
I'm sorry?
What year did you say that was? In 2018 or 2008?
Let me get that for you.
At the municipality?
2008, it was listed by the municipality as a quad.
And prior to that, it was listed with the municipality as a single family?
Not to the best of my knowledge. I only have it listed from 2008 as a quad. I don't know what it was listed out. Before that, I don't have those records.
What would trigger the municipality recognizing this as a quad?
I think the zoning department would have to answer that. They're the ones that make those decisions, not me. I would say probably there must have been a transfer of the ownership and somebody applied for some kind of zoning, and the decision was made on that.
So, I just have a question. So to sum up the municipality's position is, like, the municipality isn't disputing at one point, this may have in fact been a quadplex, right? But I think what you're saying is that by following that UNO and having that UNO approved as a single family, that's an affirmative action demonstrating that there is an intent to abandon that use and now make it a single family property. That sums up, I think, your position, right?
Yes, that sums up, I think, the first part of my argument that, one, that there was a UNO with the zoning relief showing that this property is a single family, and that was directly before the transfer of the property to the current applicant during the transfer process. So my argument is that he would be aware of this particular zoning use of this property. Two, furthermore, of my argument is that whether or not that this was deemed a quadruplex or any other type of use by the municipality or by the county, that use was also abandoned by the property being vacant and by the lack of rental licenses for multiple years on this particular property. So if it was a non-conforming use that was allowed by the municipality, that use has been abandoned. And that combined with the UNO, the transfer of the property, being moved to a single-family unit, which the current owner should have had knowledge of, that use is also has been abandoned for his purposes. And this is in the R2 district, which you are aware of, and quadruplexes are not listed as permissible uses within that. Triplexes are not listed as permissible uses. We were here to argue against a twin, but against a duplex, but we're also arguing against this triplex. That's the crux of the municipality's argument.
Understood.
Thank you.
So where we at, public comment? All right, we'll open it. Does, do you have anything else to add from a report standpoint? Okay. We'll open it up for public comment. Anybody from the public want to testify either in favor or opposition of the application, please speak up now. Seeing no public comment, we'll close public comment. Anybody want to offer any last words? It
appears that the municipality is conceding that this was approved at one point in time as a quadruplex. It's, given that fact, the use as a quadruplex is a non-conforming use, which use would continue to my client unless there's evidence of abandonment. There's no evidence that my client ever took any affirmative actions to abandon this property as a quadruplex. He's been paying taxes on the property since, you have the record that shows that his taxes are current since he's owned the property. He's paying for it as a quadruplex. He's in fact applied previously for permission to use this property as a quadruplex. I know that only because, and I'd like to bring this to the attention of the board as well. The email that I got from opposing counsel, or from counsel for municipality at 5 o'clock today, that I did not get a chance to print out or read in full, but I looked at on my phone. There appears to be at least one other application by my client filed with the zoning officer for approval of this property as a quadruplex. I believe there's also a statement made by Mr. Pradeep, I believe, in his 2020 request for a use and occupancy permit as a single-family home that the property should be a quadruplex. I think it's clear from the chronology here that the only reason that Mr. Pradeep would have asked for UNO as a single-family home was to convey the property to my client, because the agreement of sale probably required him to give a use of an occupancy permit, and that's the only one he could get. So I don't think that's at all evidence of abandonment by anybody of the use as a quadruplex. I'd like to have the opportunity to introduce the additional documentary evidence that was sent to me not in time to present to you today from the municipality that I think should have been provided before. And I think municipalities introduced part of it this evening, but not all of it. But from what I can see on my phone, I think there are additional records in there that, from which you can conclude that there was not an abandonment of the non-conforming quadruplex use. So I don't know procedurally how the board would handle that, but if I can just transmit that.
I'm sorry, counsel, I hate to interrupt, but you just stated that your client accepted a UNO that identified the property as single family. Is that correct?
Well, he signed an agreement of sale and received a deed and got a use and occupancy permit for whatever he was handed. As far as him accepting it, I don't think that's an acquiescence in the use. He bought the property with the problem.
So you don't believe that to be a concession to acknowledge that this house is no longer considered a quadruplex, if it ever was, that he accepted it as a single family, and knowing that it was a single family, he assumed any risk of this not being converted back to a quadruplex?
I don't think that's supported by the decisional law in this state. I think the Marlowe and Zoning Hearing Board case is clear that the hardship justifying a variance runs with the land, doesn't run with the person. If he received the property in a condition where that had a non-conforming use that should have justified it being restored through action for a variance, he had that right. I don't think he waived that right by receiving a use and occupancy permit that it was a single-family home.
But the person that he acquired the property from also conceded it to be a single family versus it being a quadruplex.
I don't think anybody conceded it to be a single-family home. I think that's all the seller could probably get, and that's what he got so he could make the sale. I don't think that's a waiver on my client's part of the right to ask for a variance.
But you just said it runs with the property, so if the property has conceded to a single family versus a quadruplex, if it ever was, then that also will transfer over to your client, is that correct?
No, I think it's a non-conforming use that was never abandoned, so I think that's still what it is. I don't think it was abandoned. I think it's still a non-conforming use that's valid as a quadruplex, based on the evidence we heard tonight. That fact that the seller only asked for use and occupancy permit for a single-family home, I don't see how that would operate to be a waiver on my client's part or an abandonment on my client's part.
That use has been abandoned for almost 20 years. So you're saying that the abandonment should run indefinitely until someone decides that they want to reactivate or take advantage of this quadruplex because
Well,
it's
I think
beneficial
abandonment's
to them?
is a mixed question of fact, and I think there's a rebuttable presumption in the zoning ordinance that if the property is not, his use is not used for 12 consecutive months, it's rebuttably considered to be abandoned, but that the applicant is allowed to rebut that by showing that he never did intend to abandon it. And as I stated before, I think there are documents that would support the fact that my client did not abandon it. As far as the property being abandoned for 20 years, it appears that there have been efforts going back as early as 2018 to get permission to use the property in the way that it's configured, which is as a quadruplex. It's an enormous property. The board has photographs of it and diagrams of it. It's a huge property. It's been abandoned, empty for a long time, and that could well be because nobody's gotten approval to have it occupied as a quadruplex. So it's my client's here to ask the board for this evening. Again, I think the request, as I presented it initially, was as a triplex, 2 in the big building and 1 in the candy store. And I'd like the opportunity to introduce that additional evidence. I think it's important. I don't want to prolong this again.
Are you asking for it to be
And I
continued?
can only read part of it on my phone, but it looks like my client asked for permission for a quadruplex, I think, in 20, well, there was, I saw an application for a quadruplex that apparently was denied but not appealed.
So you're saying, what exactly you want to offer is that an application for a quadplex in 2021? Is that what you're?
An application for a quadruplex after the conveyance in 2020 by my client, asking for that.
Was it
relief.
approved?
It was not approved,
Oh, it was
but he
denied.
asked for it.
Okay.
So he wanted it and continued to pay taxes on a quadruplex, which under with the Latrobe Speedway versus Zoning Hearing Board case, holds that evidence that the applicant has continued to pay taxes based on the use, the non-conforming use, is evidence that the use has not been abandoned. As far as, it seems that there's a reference to, in the 2020 application for the single-family home by the seller to my client, there are additional documents attached to that, one of which says something about the owner believing it should be a quadruplex. So there's at least some evidence to show that he did not abandon the intended use as a quadruplex.
What do you want to do, Mr. Campbell?
I don't want to continue the case again, but I think if that is an issue the board is going to, if it may be determinative of your action tonight, then I'd like you to have an opportunity to see that. I mean, I'll give you, that's my offer of proof. If the board doesn't think it's probative, then I'll ask you to just make your decision. But I think it's probative.
Okay. Anything else to offer, Mr.
That's
Campbell?
all.
All right.
Thank you.
As for the documents that were sent to Mr. Campbell this afternoon, I believe with P1, I've attached multiple documents on there, and I think some of what Mr. Campbell's addressing is attached to those documents, meaning the prior owner's statements about the property, him wishing that it was a quad, but acquiescing that this is a single-family unit for purposes of the transfer. And again, my argument is that this occurred before the transfer. The current owner received this property when the zoning relief was for the single-family unit. Any hardship that's been testified to by this particular applicant is purely economic hardship, transferring the property into, you have to list the different exhibits of what the cost would be, and then the cost is higher for doing a single family to make it conform with the current residential use of this district. That is purely an economic hardship. That's not something the board should rest solely on for the consideration. The property doesn't have any unique physical circumstances that itself make it a hardship. Hardship has to not be created by the applicant. I'm arguing that he purchased the property with the zoning classification as a single-family home. And any variance that would be granted to this property, especially for a triplex, I think would alter the essential characteristics of this particular neighborhood of this district. So based on those qualifications, I don't think they meet the necessary steps for a variance. And also, more importantly, I think this use was abandoned even before this applicant received the property. I did not present it in evidence, but it is a document from the zoning hearing board. It's part of the documents that I sent to Mr. Campbell, but in 2018, the prior owner did ask this board for relief to make this a quadruplex, and that was denied from the board. And that was prior to the request to change it to single family right before the transfer or the sale of this property. So based on that, I don't think this applicant meets the burden for a variance. Thank you.
Thank you.
I know council wasn't here for the prior hearings, but we did introduce evidence that there are multiple multifamily dwellings on that block. And all the buildings on that block are smaller in square footage than this one. This one's huge, but all of them that are close in size are all triplexes or multiplexes, and we did introduce evidence of that at the prior hearing. So in terms of the argument that this would alter the character of the neighborhood, I don't think that's founded. There are singles on that block, there are multiplexes on that block, but this building is kind of unique in that it's at least 400 square feet larger than anything else. It has a bump out side building. It really would not alter the character of that neighborhood to make it a multi-unit building, in this case, a triplex. In terms of the economic harm, I think we've established through I don't think the argument that only economic harm is the test. In fact, the question is whether it's unduly burdensome to conform this building to the terms of the zoning ordinance. And you have evidence that it would cost an additional $70,000 above and beyond the cost just to rehab the building to make it a single-family home again, which is just prohibitive and economically just not feasible. If the relief's not granted here, this building is just going to probably, I imagine will sit there, well, I don't know, nobody knows, but it's likely just to sit there as is, as a boarded up abandoned property that's economically not practical as use as a single, as much as Willow single homes in Norristown. This one's just very big and very beat up and not likely to be used as a single-family home again.
Thank you. Board, want to make a motion to close? No, your council already summed it up. Board, want to make a motion to close? Is there a second?
Second.
All in favor? Any opposed? Motion carries. Is there a decision on the application? Executive? We're going to go off the record briefly for a quick executive session. All right, we're gonna go back on the record. So we made a motion to close. That motion was successful. Next thing is somebody want to make a motion for a decision on the application.
I'll make a motion for case 53-25 for 705 Chain Street, that we deny the requested quadplex, but approve a triplex.
Somebody want to second the motion?
I'll second that motion.
All in favor?
Aye.
Opposed?
Aye.
Aye. Any abstentions?
Aye.
All right, so it's 2-2 with one abstention.
No. I'm saying aye on denial.
Denied, okay. So, motion is denied. The requested relief is denied then, based on the motion. All right, we're gonna go to the next application. The next application is 25-26. It's a request for a variance and a special exception. The applicant is Earl Walls, 50 East Brown Street, Norristown, PA, 19401. Property location is 0 Moore Street, Norristown, PA. The property owner is Walls Enterprises LLC, 50 East Brown Street. The applicant is requesting relief from sections 320-291A1B to construct a single-family detached dwelling on the non-conforming lot, which does not comply with the side yard setback in the R2 district. Relief from 320-42B3. Dimensional criteria to provide a side yard setback less than 5 feet in the R2 district. Relief from 320-42A1 to permit a front yard setback less than the minimum required in the R2 district. And relief from sections 320-262A4, sections A through G, to permit the front yard parking and front-facing garage in the R2 district. Good evening again, Mr. Campbell.
Yes, thank you. Charles Campbell for the applicant. This is a request for a dimensional variance and for a special exception. It's a new construction project, proposed project on the 700 block of Moore Street. I have exhibits I'd like to introduce that show the architect's drawings for the proposed property. Which I'll have marked as A1. Testifying will be the applicant, Earl Walls, and Kevin Sims, his architect.
Get them both sworn in?
Would you each state your full name, please?
Earl Walls, Earlwalls.
Kevin Sims. Correct. You both solemnly swear affirm the testimony you're about to give with the truth, the whole truth, and nothing but the truth? Yes.
Yes.
Thank you.
Mr. Sims, where is this property located?
East Moore Street, Norristown.
Okay, so it's listed as 0 Moore Street, so could you identify for the board what block it's on, where it's located?
700 block of Moore. 700 block of Moore Street.
And what do you propose to do with your property?
Construct a single-family house, 3-bedroom, 3-bath.
Can you describe the immediate surrounding area where you propose to build this house?
On the same side, I have 4 row homes to the right, the vacant lot to the left, the single-family, and then following down the block, it'll be 3 more row homes. So it'll be my single and the single next to mine.
And your lot, you own the lot, correct?
Yes.
Right. And what is it between?
It's between, I guess, 1 single on the left and 4 row homes on the right.
Is your lot different than any of the other lots?
It'll be one of the only singles on the block.
Is it narrower, wider, or about the same as the other?
It's about the same.
And is it correct that your proposed construction would not conform to the side yard setbacks and the front setbacks?
Correct.
Why is that?
If I make the side yard, it would make the house significantly skinnier and losing a bedroom count.
So what are you asking the board to grant in the way of relief for your side yard setback?
To grant the relief to make the house a little bit larger.
How much distance are you asking the board to allow?
2 yards, 2 feet, I mean. Is it 2? It's 2 feet, right? 2 feet.
2 feet on each side?
Yep.
What difficulty will you have with this project if you don't get the 2-foot setback on each side?
If I don't get the 2-foot setback, I'll lose a bedroom count.
Can you describe the configuration of the house you want to build?
The base floor will be a basement, single or 2-car garage. Second floor will be the kitchen, living room, open floor concept. The next floor will be the bedrooms, bathroom, and the laundry.
What else?
And the rooftop deck on the following floor.
So how many bedrooms in total?
3 bedrooms, 3 bath.
And you would lose a bedroom if you were not given the side yard variance? Is that
Yes.
your testimony? Okay. What would the configuration be if you know, and if you don't know, that's fine, just say so, without the granting of the side yard setback?
It'll be a 2-bedroom, 2-bath. It would just be the loss of the master bedroom.
Okay. I'd like to, I may want to ask more questions, but I'd like to turn to Mr. Sims now, just to get some more
Sure.
clarity of the project. Okay. Mr. Sims, do I need to qualify him, or can I just offer him as an expert witness in architecture?
Yeah, Mr. Sims has testified here many times, we're familiar with him.
So he will be asked to offer opinions on architectural and
Yes.
architecture and design. Mr. Sims, were you the architect retained by my client to draw the plans for this proposed building?
Yes.
And is Exhibit A1 a copy of your plans?
Correct.
All right, can you just, starting with the first page, describe what A1 consists of?
Well, the first page is just a general site plan, the property layout, and then just general impervious areas, the building area, lot area, overall coverage. And then just based on the Norristown code, the township, and current IBC and IP for construction types.
Okay.
Second page is just a general floor plan and give you each room layout, each room square footage. And then the third page is just a structural details of the foot and foundation notes for the lower level, and then it's the slab on grade details. And that would be A1.2. And then A13 is the general framing notes and construction types and buckets. A14 is, I have concrete flashing details with window opens and rough opening details, including the sills and door frames. And then A14 is the general elevation, the front, side, and rear of the building. P1 is just electrical, P1 would be plumbing, and M1 would be the mechanical, like corporate systems.
Okay, now the issues listed on the agenda for this evening are, one, alteration or extension to construct a single-family detached dwelling on the non-conforming lot which does not comply with the side yard setback in the R2 residence district. And dimensional criteria to provide a side yard setback less than 5 feet in the R2 residence district. Do you understand those to be the requirements of the zoning ordinance?
Yes.
Why is it, in your view, necessary for variance or special exception relief to, from those sections of the ordinance?
Well, the problem I was running into was I can't accommodate the hallway and the stairwell with the garage on the first level with the 5 feet. So I'll lose 2 feet, so I'm gonna leave 4 feet inside the building. So I couldn't put a car in the garage and have the means to get a stair and a hallway through the first level itself. Then I ran into the same thing on the second floor with the bedrooms. So the bedrooms, the bathrooms, and then the corridor, the stairwell. I couldn't get all on one side. Spots within 2 feet lost on each side. That was one of the major reasons. Because the plan wouldn't work.
Okay. Before coming to this hearing tonight, did you observe the width of the lot and the width of the lot as compared to the other lots on the 700 block of Moore Street?
Yes.
And how does this lot compare to the others?
This one was a little bit narrower than the one next door to it. The one next door has I measured it this morning, was a 24-foot house with another 12-foot lot next to it. I guess that was the side yard it had. But on that side yard, one side had window up and one didn't. So I don't know if it's something there originally. It was something that was taken down, but it was stopped recently.
Okay. So if this relief is not granted, is it correct that the house, if it were built, would be narrower than the other houses on the block? Yes?
Yes.
What effect, if any, would the granting of the variance from the dimensional criteria have on the block and in the neighborhood?
No, I mean, I still accommodated the 3-foot setback, only setbacks on each side. So there's still setbacks in the design. It's just not 5 feet, it's 3 feet.
Or was it 3 feet or 2 feet that you're seeking?
No, the original variance wanted 5 feet, so I had a 3-foot setback rather than 5 feet. So it's a difference of 2 feet on each side.
So you want to make it 2 feet smaller for a total of 3 feet?
Correct.
All right, so the project, if allowed, would have 3-foot setbacks on each side?
Correct.
Is that an unusual amount of side yard setback?
No, that's usually the standard. You have any windows or doors protruding next to the property lines require 3 feet.
Now, the other two issues listed were to permit a front yard setback less than the minimum required in the R2 residence district, and residential parking and garages to permit the front yard parking and front-facing garage in the R2 residence district. Do you have an understanding as to whether that is still an issue in this case?
The front yard setback I resolved. It was required to be 25 feet, so I made it 25 feet. So that one is resolved. The front parking seems weird because every other house on the block has front parking. The garage I haven't addressed yet. But I assume you want less cars on the street.
Is the issue that you resolved for the front yard setback, is that shown in the,
The current drawing, yes.
The current drawing?
25 feet.
so is it correct that all the houses on that block have space for 2 cars in the front?
Yes.
The only difference here would be that this house, as proposed, would have a garage as well.
Correct.
We don't make the driveway any longer or shorter.
No.
Would that have any negative effect on the neighborhood if the garage were not, if the garage were allowed?
No, I think it would be better with one less car out there.
I don't have any further questions of Mr. Sims.
Any additional witnesses?
Anything else you want to add? No, I think that's all. Thank you. I move for the omission of the exhibit.
I just have one question to get started. Can you provide maybe a point of reference of where this is located, like between
If you're going-
7 something and 7 whatever?
743 Moore Street.
If you're going
740.
towards Sunny Hill Road, it's on your left.
Between 743 and what?
If you're going on Sandy Hill Road, I think it's the last block of Moore Street.
Yeah,
and
but it's
it's on-
between, the neighboring property is 743.
Is it, and this one is an end unit?
It's an infill, it's next to the other, it's to the left of 743.
To the left of 743. Got it.
The proposed structure is going to be similar in design or completely different from the existing structures adjacent to it?
The only thing different will be the garage, but it'd be similar in design,
The design?
yes.
Was this property always its own lot? Or
Yeah, I
was it-
bought it vacant.
Okay, do you know if it was previously part of one of the other neighboring
I
lots?
think the person that developed the houses, this was the last lot that they had left.
Okay. How will you, I just don't know, go about getting it an address that's like more aligned with, like,
I guess during subdivision, maybe, I don't know, I guess, I'm thinking it would be the 741 would be the next number. I guess the planning would assign an address, a physical address.
and just to make sure I heard it correctly, is the side yard setback is proposed to be 3 feet on each side?
Right.
Okay. And that's wide enough to, I guess, bring your trash can from back to the front? Will there be, will they be paved or lawn?
It'll be long. Whatever, the 2 sides will be long.
Okay. Oh, one more question for me. It looks like not all the houses on that block are, like, they don't all start, the setbacks aren't all the same. So will it align with the next door neighbors for where the setback will start?
Both sides. That's what I did, I designed it for match both sides of the front page.
Okay. Okay. That's all I had.
To your knowledge, were there any previous structures on this lot
No.
prior to acquiring it?
No, it's been vacant since.
Did I hear you mention testimony about rooftop pad?
Yes.
So the height of how would that compare to the other buildings along that road?
I think we're at 40, what are we, 40 feet?
Yeah, 40 feet.
And what is that compared to the other ones, the existing?
Still way to go. there, pitch roof, he's on a flat roof, I mean, it would be, you can't see a roof being no more than 36 next door. Only thing is on a slope too, so each roof that goes down in the hill goes farther down.
So it looks like Pannoni called out that the height, and it looks like they note that building height to be no greater than the median height of the buildings on the block of the same residential use type, but in no case shall exceed 40. And then they also note that the buildings on the block are 1 story and 2 story, and the proposed is a single family 3 story. So how do you get around that provision without additional relief?
Well, that height,
Unless I'm reading it wrong.
well, the height issue wasn't listed on the list of issues for hearing tonight, so if the board wants to entertain that, I would need to establish the height of all the other buildings on that block, because that was not.
So you're saying Klein is willing to make it conform with whatever the requirement is, or seek additional relief later? Is that what we're?
Well, I don't have the evidence to introduce other than, you know, my own word, which isn't evidence, but I have observed that there is another building on that block that is as high as as the proposed building, and the height of this building as proposed does not exceed it. As far as the median height is concerned, that would require measuring every building, which I would have done if that had been listed as an issue for hearing tonight, so
It's not an issue. I mean, I guess the option is you're either going to develop the property in line with the requirement, or you're going to have to come back and seek additional relief. I mean, for us, it's not, we don't have to decide on it. That was just a question.
I have a word with my client.
Yeah, sure.
Okay, my client's willing to agree that he'll conform to the 40-foot limit for height, so that we won't be asking for a variance on that point.
What does that mean as far as configuration now? Does it mean a whole different bedrooms layout, or?
No, that wouldn't affect it. I mean, we start with the slab on grade floor, so that would be 10 feet. Then you do 9 per floor, you only add 28. By the time you do the roof, you probably have that at 35.
So same 3-bedroom, 3-bath, just no rooftop deck, is that what we're saying?
No, you still want the rooftop deck.
Oh, so you can make that happen within, okay.
Even with the pilot, like you doing
Anything else from the board, any other questions? And then the Pannoni letter also mentioned impervious coverage. I assume that was figured out before.
Yeah, I reduced the square footage of the building.
Got it, okay. I have no additional questions. If you got them. Go to the municipality.
The subject property is a vacant residential lot located in the R2 residential district. The applicant proposes to construct a single-family dwelling with a front-facing garage and driveway parking.
All right, we'll open it up for public comment. Anybody from the public want to testify either in favor or opposition of the application, please speak up now. Seeing no public comment, we'll close public comment. Mr. Campbell, any closing?
Just briefly, the requested relief would make this property as built conform to the width of the other buildings on the block, rather than it being more narrow and perhaps unsightly. The proposed reduced setback we submit as a de minimis amount and allows for access for emergency personnel, trash cans and so on, by allowing for a 3-foot wide path. In terms of the garage, the driveway would be the same length as everyone else's. The garage is incorporated into the house, it's part of the house, it's not a detached garage. It would relieve parking on the street and therefore be beneficial to the neighborhood and to motorists. And the essential character of the neighborhood would not be changed by the requested relief. So I would ask the board to approve the application.
Thank you. Board, want to make a motion to close the hearing for this application?
Motion to close case 2526.
Is there a second?
Second.
All in favor? Aye. Any opposed? Motion carries. Is there a decision on the application?
I'll make a motion to approve application 25-26 for the requested relief.
Is there a second on the motion?
Second the motion.
All in favor? Aye. Any opposed? Motion carries. The requested relief is granted. Yep. All right, before we get started on the next application, it appears that we may not get to everybody. Pursuant to the zoning hearing board rules, we do not start applications after 10 o'clock. So anybody want to request a continuance now while we have a little break? Not, we'll keep going and we'll hear as many as we can. All right. Next application is 20-26. The request is for a variance. The applicant is Red Badge Management LLC, 49 Devon Park Road, Suite 302, Wayne, PA, 19087. The property location is 307 East Erie Street, Norristown, PA. The property owner is John D. and Stephen A. Alteri of 318 East Erie Street, Norristown, PA. The applicant is requesting variance from section 320-141, use regulations to permit the use of a dead storage facility in the Town Center 2 district.
Good evening. My name is Mike Clement, and I'm here on behalf of the applicant, Red Badge. The principal and owner of Red Badge is with me. It's Robert Birch. And if you would allow me, I'd like to make an offer of proof with respect to this application.
Any witnesses this evening?
Mr. Birch will be my only witness with respect to the application.
Okay, how about we get Mr. Birch sworn in while you're passing those out?
Great, thank you.
State pledge allegiance. Robert Burke.
B-U-R-C-H.
Does not swear or affirm the testimony about the truth, but the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
I think board members and the officers here know the property. Altieri's been there forever. It's a full-service meat packing and distribution company. It takes up 2 properties on either side of Airy Street, right, almost next door here, right up the block. The building that we are here for is the building that's across from the main processing operation, which is on this side of the street where we are tonight. And it is a warehouse building. It's a pre-existing non-conforming use, and it has been used for a warehouse building for decades. It has, when we get to some photographs, or maybe we ought to do that right now. What you have in front of you is a packet, and the packet has, as if I may, A1 application with the payment receipt. A2 is the Board of Assessment summary of the property. A3 is the Board of Assessment sketch of the property. A4 are Google Maps, aerial views, and street views, which are photographs. And A5 is the agreement of sale to show that Mr. Birch's company, Red Badge, is the equitable owner. And I think the easiest thing to start with is just a visual, because it helps me. And if we look at A3, the first page in magenta color is the building itself on the lot. If we look at A4, we have an aerial from above, which again shows the building on the lot. A4 in the second page shows the Airy Street view with the front doors to the property. The next photograph in A4 shows the parking area, which is interesting from our perspective in terms of proof, because it does show the loading dock at the very rear, it shows the Altieri truck, and it shows the loading dock ramp, which are both, all three, I should say, in the photograph. And then the last shows the corner of the property, which is the last photograph under A4. So Altieri has used the property, as you know, and it's been a warehouse in connection with their meat packing. My client proposes to use the property for, quote, dead storage or simply storage. My client runs a business, which is a property management business, and it entails a number of properties. And in those properties, there are moving parts, furniture, equipment that go in and out of the properties. He has stored these things in various places. This is a perfect place to store them. He does not want to do any kind of retail, no kind of sale, very limited, perhaps one trip a day where people either pick things up through his business operation or drop them off in connection with the property. We believe that Altieri, as you know, has operated anywhere from 5 to 7 days a week. It's common knowledge, has had 20 to 40 employees in and out of both of those buildings all the time. This is a much less intense use. He is not asking for any kind of relief with respect to anything on the property. It will remain the same from the exterior. The interior he will fix up in terms of making sure it's neat and clean and spacious for the things he needs to put in there and take out of there. He will testify or confirm my testimony that at most there would be, as I mentioned, one trip a day, maybe 2 trips a day, but certainly much less intense from what has been in use on that property. You will note in the Exhibit 2, where the description is set forth in the assessment office. It's noted as a one-story warehouse, WHSE. This is the 4th line from the top on the first page under Exhibit 2. It will set the use of the property as one-story industrial, WHSE, warehouse, MFG, manufacturing. And that is the way it has been listed in the public records. You will also note in the exhibit under 3, in the small print, it indicates again that it is a warehouse use on the property, and it has a asphalt paved parking lot and a fence. So, not to belabor the point, I think that the ordinance permits pre-existing non-conforming uses to continue, and this is a less intense use than is already there, as a result of which we're asking relief, which through this process, through the variance process, is mandated for my applicant to go through. So if you have, if I may, I will ask him a simple question. Bob? Sir. Have you been here throughout the offer of proof that I have just made to this board?
I have.
And have you heard what I've said about the use of the property in the past and the use you intend to make of the property?
I have.
And if you were to testify, would you adopt the statements that I have made as being part of the record for your testimony with respect to this application?
Yes.
Okay, thank you. I would like to ask the board if they have questions. We'll be happy to answer them.
So just one question, just make sure I'm grounded. The current use of the property, we're saying, is a full-service meat packing, processing, wholesaler, and warehouse. Is that the current use of the property?
The current use of the property is in connection with that operation. So they, on the south side of Airy Street, they have their main processing plant. On the north side of Airy Street, which is where this property is,
Yeah.
they have, it's been used as warehousing for various things in connection with that process. So what we're asking for is just to buy this one piece and to use it simply for storage.
Maybe I'm apologies, maybe I'm not following. You're saying the current use of the property is warehouse and storage?
Yes, but much more active. It's in and out all the time in the process they have paper products, they have boxes, they have processing machines and so forth. And Alteration has used that property across the street constantly for those type of things where they load in, load out, and so forth. So yes, they're using for an active warehouse distribution.
So you're saying you're going to essentially disassociate that with the meatpacking business and use this for some other standalone?
Just standalone warehouse storage. And I'm sorry I didn't make that clearer in my presentation.
The items that you're going to be storing or that your client plans on storing, is it strictly furniture or is it like equipment for lawn mowing and stuff like that? Or?
No, I think it is. It's going to be mostly furniture. There will be some, I think, electronics.
Not much. It's mostly personal, household type items, furniture, office equipment, things like that. Nothing like a lawnmower.
Are these things used for furnished apartments, or are these things that are left over from people who occupy the units?
Most of it is my own personal property, either from companies that we own, desks and things of that sort, or from different houses that I have. So it's, yeah, personal property and office equipment, office furniture and stuff.
Do you have a proposed operating hours when these 1 or 2 a day pickups would happen?
No, there'll be no one here. Once a week, once a day is way more. This is much more of a once a week, maybe even less.
But no overnight or early morning, typical business hours?
During the workday, just come, you know, literally, I have a barn full of equipment and housing stuff in Montana that I need to bring back here that I will move in there and probably won't touch it for a year. So it's really just to consolidate a lot of different storage that I have from different companies I've owned, different houses I've had, bring it back into one place and slowly work my way through it and get rid of it, and then come up with another use for the building over time.
Thank you.
Is there any proposal to sublease this as storage, or is it going to be solely for?
We may want to be able to sublease it at some point if the board felt that we should come back and get permission to do that. If that wasn't part of this variance now, that would be fine with me initially. We'd be happy to come back and discuss that further. But for the short term, there's a fair amount of work that needs to be done over the next 6 months.
Is there any intention here to turn this into a storage facility?
Not at this time.
In the future?
Perhaps. I don't know.
What we're asking for, the relief we're asking for tonight, just to be clear, is simply for storage, not a storage facility, not short-term rental storage facility, anything like that. If there is in the future a desire to use the property, we will come back to the zoning hearing board. But right now, all we need or are asking for is storage.
And the relief that you're requesting today, did you apply for a UNO and it was denied and that's how you ended up here? Or like, what triggered, why are we here today?
The reason we're here today is because we did try to determine if perhaps we could do this without coming to the zoning hearing board, and we're advised that we should come to the zoning hearing board, and that's why we're here.
As a layman, it's a little confusing. You know, in going in to purchase the building, I was told I can't occupy the building without a UNO, and prior to purchasing it, I needed permission to do this, that, and the other thing. So we're really I just want to make sure I can use it for what I want to use it for without getting, I want to get permission prior to making that final.
We were here for the first hearing.
So you occupy the property today, but
No.
through a lease?
No.
We don't own the property. Our applicant has it under agreement.
We're scheduled to close on the property on Monday.
Yeah, Mr. Matthews, I said we are the equitable owner, which means that, and I should have been more clear about this, I apologize. Equitable owner meaning that we have an agreement to purchase the property, so we have an equity in it. We do not own title to the property, nor will we own title to the property until Monday, and we will only own title to the property if we're granted relief here tonight.
Oh, okay, I got it, I understand now. In my head, I thought you were representing Altieri, but you're not, you're representing Red Badge Management.
Correct.
I'm thinking you are the owner-operator of the building today.
We are not.
I get straight in my head now.
Thank you.
Any other questions from the board? All right, we'll go to the municipality.
Subject property is located in the Town Center 2 district, operating currently as a warehouse. The applicant is proposing to keep on use the property as a storage facility for office and furniture supplies.
Thank you. We'll open it up for public comment. Anybody from the public want to testify either in favor or opposition of the application, please speak up now. Seeing no public comment, we'll close public comment. Any summation?
No, sir, thank you.
Got it. Is there a motion to close the hearing for application 20-26?
So moved.
Is there a second?
Second it.
All in favor?
Aye.
Any opposed? Motion carries. Is there a decision on application 20-26?
I'll make a motion to approve application 20-26 for the requested variance.
Is there a second on the motion?
I'll second it.
All in favor?
Aye.
Aye. Any opposed? Motion carries. Relief is granted.
Gentlemen, ladies, thank you very much for your time. Appreciate it.
Thank you. Any other requests for a continuance? If not, we're moving on. All right. Next application is 28-26. It's a request for a variance. The applicant is Mahuva Realty LLC slash Daipen Patel, 7002 Dorsam Way, Ambler, PA, 19002. Property location is 1820 Markley Street, condo number 3, Norristown, PA, 19401. Property owner and the applicant are the same. The applicant is requesting relief from sections 320-311A14 to provide one loading berth for the proposed retail and restaurant uses in the commercial retail district, and relief from section 320-328 to permit a freestanding sign area of 36 square feet and to provide 6 wall signs with a maximum area of 35 square feet where only one is permitted in the commercial retail district. Good evening.
All right, good evening. My name is Mike McGinnis. I'm an attorney with Begley Carlin. I am here tonight on behalf of the applicant, Mahuva Realty LLC. I will have 2 witnesses this evening. I have Anna Bott of Arna Engineering, and I have Mr. Patel. If I could have them sworn in at the outset, I will state that my request and suggestion this evening will, after my summary at the outset, I'll procure testimony from Mr. Bott going over the site plan and the variances that we're seeking, and then have, if it's the board's pleasure, Mr. Patel sworn in and offer of proof in a colloquy.
Sounds good.
Could you state and spell your full name, please? Sir, would you state and spell your full name?
Dipin Patel?
Thank you. Sir? Do you both solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
All right, thank you. Good evening. As I indicated, I am here tonight on behalf of the applicant. I have Mr. Patel and Mr. Bott with me. The subject property is located within the Norristown Center Shopping Center, which is, as you can see on the site plan before you, along West Johnson Highway. It is located in the CR Commercial Retail Zoning District. The property address is 1820 Markley Street, and the subject lot, which is the plan north or northwest, you can see it's a rectangular shape outlined in blue, is approximately 1.9 acres. As you can see, we have a digital display this evening with a couple exhibits. Mr. Bott also has the boards. We have one paper copy of each exhibit, if I can provide that at the conclusion if we need to admit those into evidence. The application that we have before you this evening seeks 2 variances, which would permit the redevelopment of a previously developed pad. I will state the record, and we're toggling to this. It's okay. The prior development had a larger footprint, and that use has been demolished for a number of years. What we are proposing as part of this application, which if approved at the zoning hearing board will subsequently go through the land development process, is a new multi-tenant commercial building which contains 5 retail units and 1 drive-through restaurant. The total building area is approximately 13,600 square feet, and as you can see on the site plan from left to right, you have 5 retail units. They range from 2,480 square feet on the far left to 2,000 square feet near to the far right, and then you have the QSR unit on the far right that is 2,800 square feet. And then you can see the associated site improvements, the parking, the stormwater management facilities, the green space, the landscaping that we're proposing. And then you have the route for circulation around the structure. And then you have the loading facility that we are proposing as part of this application, which is to the immediate left of the proposed structure that we are proposing to construct at the end of this process. The site is already served with existing curb and sidewalk, which we are going to be retaining and tying into where feasible. And as I indicated, subsequently, after we go through zoning, we will embark on the land development process. The requested relief that we have, I would suggest, is fairly narrowly tailored. We are allocating one space for a loading berth. The ordinance in the township requires 3 for this proposed use. And the testimony that we're going to offer this evening will indicate that given the size of the retail spaces and the sorts of tenants who are likely to occupy the spaces, this will function perfectly well with one loading space. The loading hours of operation will be off-peak hours. These are not the sorts of users in these retail spaces that are going to require multiple different loading zones or large trucks, and we are more than confirmed that with this use and with this layout, the one loading space and the one loading berth would be sufficient. The second variance that we're seeking relates to the signage that we're proposing as part of this application. So the town ordinance permits a 15 square foot maximum freestanding monument sign, and then it permits a wall sign, one wall sign, that is provided for the frontage in this lot. As you can assume, when we're proposing a multi-tenant facility, a commercial facility that has 6 different uses, we are trying to allocate space so that each of the end users has adequate signage. There's a variety of reasons why that would be appropriate and necessary, but we are going to comply in all other regards. We're just asking for permission to have the appropriate advertising for each end user. The freestanding sign is going to be 36 square feet. That would allow for approximately 6 square feet in space for each of the 6 tenants at the end of the day. We think we can place this in an area that is sufficient. You can see on it, if you can point this out, the freestanding sign is near the plan northwest, right there. It's going to be tactfully done, and it will provide sufficient advertising in a way that would attract the sort of tenants that I think Norristown would like to come into this site. So in summary, really, the important part of this application is we're redeveloping a site that has been derelict for a number of years. We're adding green space, we're adding stormwater management. It's a good use, it's a permitted use for this site, and we're asking for 2 variances to facilitate adequate advertising and to allow for the loading space to be located where it is. If we were to try to accommodate the additional loading on site, the only way to do that really would be to add additional impervious, to remove parking, to reconfigure the site, or to potentially place it in the area that Anna's just advertising on the screen before you. And we don't think that that is the best use of the site, given the comfort that we have that one loading space is going to be more than sufficient with our use. With that, I would like to have Mr. Bott come to the podium and provide testimony. Thank you. All right, Mr. Bott, can you please reiterate your name for the record?
Sure. Good evening. My name is Anand Bhatt.
Okay, and where are you employed?
Arna Engineering.
Okay, and did your firm prepare the plan and associated materials with this application?
Yes, we did.
All right, just can you briefly describe the existing conditions on the site that we're proposing to redevelop?
Sure. The existing condition is the vacant condo lot along West Johnson Highway. It's approximately 1.9 acres of land, which was previously occupied by the building. A portion of the building has been demolished, and existing parking and dry aisle area still remains. There are 2 accesses coming from West Johnson Highway, one between Dunkin' Donuts and the proposed parcel, and the other one is to the east of it, east of the parcel, which also goes to Royal Farms and the office building, which has the driving center in it.
Okay, and now, Mr. Bott, if you toggle to the proposed site layout, if you could walk the board through what we're proposing and how the site will function post-construction.
Sure. Yeah. As Mr. McGinnis suggested, this is going to be a multi-tenanted, multi-use building, 13,600 square feet in total area with a small patio outdoor, with a end cap being a drive-through restaurant. We have stacking of 10 to 12 cars shown on this plan. We also have 2 trash enclosures shown on the proposed project, one for the restaurant and one for the retail uses. Also, the loading zone is located to the west of the proposed building, which is right here. So the trucks will come in and will be able to go into this area. We are anticipating most of the delivery is going to be through small box trucks, and if there is a tractor trailer, that can also be accommodated through this area. We have done the truck turn for this proposed development.
And there was a prior approval, in fact, for a larger development than what we're proposing here, is that correct?
That is correct.
Okay, and that also had, what, 1 loading space associated with that?
That also has one loading space associated with that.
Okay, and we're proposing a loading berth that is 15 by 50, is that correct?
Yes.
And then based on your experience, would that be sufficient to accommodate the loading needs of the sorts of retail tenants that would occupy a multi-tenant facility like this?
That is correct.
Okay. Is there any, I made a sort of offer of proof or a statement at the outset that compliance with that section of the ordinance would require a revision to the impervious surface tabulation. Can you just indicate to the board where you believe the additional loading berths would be placed if we had to comply with that section?
Yeah, so loading berths will have to be placed along this portion of the site or along this portion of the site. Both of these areas will have to be, again, the parking will have to be lost, as well as some of the green space along the back will have to be reduced due to the paving we would need for loading air spaces.
Okay. And we are in fact reducing the impervious surface as part of this development, correct?
We are,
from what was good.
Yes, we are reducing the impervious coverage from what was approved from previously approved on the larger building.
Okay. And then I made the statement at the outset that the loading times would be off hours with the businesses. Is that your understanding as well?
Yes, that is my understanding as well.
Okay. We have zoning relief that we're seeking with respect to signage. Is that correct?
Yes, we are.
And that is with respect both to the wall signage and to the freestanding signage. Is that right?
Yes.
Okay. You highlighted as part of my summary the proposed location of the freestanding signage, and that on this site is to the planned northwest. Is that correct?
That is correct.
Okay. And we're proposing the construction of a sign that would allocate approximately 6 square feet of space for each of the 6 tenants that would be occupying this building. Is that right?
Yes.
And the ordinance right now only allows for what?
15 square feet.
All right. And for a multi-tenant facility, do you believe that that provides sufficient advertising?
Yes, it is the least amount of relief needed to provide clear direction and legible advertisement for the tenants we have.
Okay. Is there any risk with respect to the placement of the sign that it would cause any hazardous traffic conditions where it's located?
No, that would be properly placed.
Okay. The ordinance has restrictions with respect to the wall signage as well. Is that right?
That is correct.
Okay. And what are we proposing versus what is permitted?
The ordinance permits only 1 wall sign per frontage for any premises. That means we will have along West Johnson Highway, we will only have 1 wall sign along the entire building.
Okay. And we're looking for 1 wall sign with respect to each of the tenants. Is that correct?
Correct. To clearly identify each of the tenant and their products and their services, we would be providing each tenant with 1 wall sign.
And the rest of the requirements in the zoning ordinance, we either comply with or existing non-conforming conditions, correct?
That is correct.
Dimensional standards, the use, et cetera.
Yes, we comply with those.
Okay. And then going through the rest of the process, if the board were to grant relief tonight, we will go through the process and we will conform with any of the requirements of the township engineer, stormwater design, and the like. Is that correct?
Yes.
Okay. Is there any reason, in your opinion, Mr. Bott, that this would be detrimental or harmful to the community or the surrounding area if approved?
No.
Okay. I have nothing further at this time.
No other witnesses?
Yes. Mr. Patel, can you please state your name for the record?
Dipin Patel.
And are you the principal of Mahuva Realty LLC?
Yes.
And that's the owner of the subject property?
Yes.
Okay, did you hear the summary and the testimony that I offered to the board at the outset
I
this
did.
evening? Okay, and also the summary that was provided and the testimony offered by Mr. Bott, is that correct?
Yes.
Okay. And if I were to call you to offer your own testimony this evening, would you so adopt the summary that I provided the board as your own testimony?
Yes.
And was that summary true and accurate to the best of your information, knowledge, and belief?
Yes.
Okay, I have nothing further. Thank you.
Thank you.
Any questions from the board?
Yeah, where's the drive-through going to be again?
Good question. Drive-through will start at the back of the building and continue through. This would be the pickup window, and then you will be able to come to the stop sign, either make a left or right going out this.
And where is the, I guess, the PA system or system that you're going to use for the
Right here.
placing orders?
So that's the menu board and the PA system.
And where is the loading dock at? Will that obstruct people's access to that particular drive-through based on the fact that the loading dock is there?
No, we have run the truck movement as a part of our application. Before we even got to the zoning hearing board, we had submitted a sketch plan to the municipality and has been reviewed by the engineer. We had shown the loading space in this area. This building is 80 feet deep, whereas loading dock needs to be only 50 feet deep. So there is adequate space for the car to make the turn and go in. As a matter of fact, we are also proposing a bypass lane which goes through. So there is adequate space based on the truck movement or the car movement we have performed for this drive-through.
And what are the hours of the drive-through service?
Again, we have not identified the user yet. So one thing we know, that it would not be a coffee shop. So it would not be opening at 5 o'clock, just like Dunkin' Donut, because the applicant, the owner, also is the owner of the Dunkin' Donut at the corner here. So it would not be a coffee shop. So most likely the hour of operation would be somewhere around 7 a.m. to 8 p.m., 9 p.m. basically.
And I'm sorry, you might have answered this question already, but what are the prospective hours for use of that loading dock?
We have not identified the uses or users yet, so we would not know until then. But as Mr. McGinnis suggested, we will be proposing this loading dock to be used during non-business off-peak hours, so that there is no disturbance to the other tenants. This information will be put in the leases as well, if I understand correctly.
Thank you.
Probably no way to guarantee that though, right? Considering you don't know what type of businesses these are going to be, what type of flow of like commerce or whatever their materials that they have that they're dealing with. You probably can't guarantee what their loading hours are going to be. Am I
We can't
correct?
guarantee the specific hours because we don't know who the end users are going to be yet. I think probably have a guess as to who they might be. I think in any scenario, it's very likely that the loading hours would be in the morning when the retail spaces probably are not open yet. I think that's a safe bet regardless of who the end QSR user is. Some QSR users that you can imagine, their hours of operation would be closer to late morning through the evening. There might be some that are open, at 7, 8 in the morning. But typically, you would have, if it was an operator that was open at 7 in the morning, you might have a box truck that comes in at 6 and unloads. And I think in this instance, where the loading is placed to the center of the parcel obviously at a commercial center, that loading, if it were to occur at 6 in the morning, would not have a negative impact on the retail users, which wouldn't be open, nor would it have a negative impact on any of the surrounding properties, because the Dunkin' itself right next door is going to be open earlier than that. So even if it's at 6 in the morning, even though we can't guarantee that, we can be pretty confident that it will not have a negative impact on the surrounding parcels or the retail tenants.
I'm curious from Mr. Patel, the idea of a strictly drive-through restaurant. Can you explain to me the thought process behind that rather than just maybe a regular fast food restaurant?
All the restaurants now coming up as a drive-through, so.
It's not strictly drive-through. It has a 2,800 square foot space. It just has a drive-through
Okay, all
component
right.
to it.
Okay, all right, now I understand. I thought it was like just a drive-through restaurant.
No.
Okay, all right.
I had a related question too. I see there's a proposed patio in front of the proposed restaurant.
That is correct.
Would that be like outdoor seating or just an open area?
Outdoor seating.
Okay, thank you.
Well, Mr. Patel, I mean, this is a quite an undertaking. I suspect you have some idea of the types of businesses that would be inhabiting this space. Could you give us some idea of what thoughts you have in that regard?
I mean, we haven't looked for any tenants yet, but, you know, it's like Verizon, AT&T, or, you know, Country, or some sort of, maybe the restaurants on the right, and anybody like pizza shop or anything.
So you mentioned box truck. Do you anticipate there might be a delivery that would require, I guess, a 18-wheeler or something of that size?
Not 18-wheelers, but this loading dock is designed to handle a tractor trailer so that sometimes restaurants have the 18-wheeler, not 18-wheeler, but the tractor trailers delivering it. That loading dock can accommodate the larger trucks as well.
I think it's unlikely, but it is designed if it's required.
And you still believe that a tractor trailer would be able to make its delivery at 6 a.m. prior to any other businesses opening that would require them, consumers to drive through the drive-through section?
No, I don't think so.
We get it. They can deliver, right?
Yeah, they can deliver anytime, I mean.
And can you, again, if I may, is Dunkin' Donut, you guys have the delivery?
Yeah, we have 18-wheeler that
They've
comes in, into Dunkin'. We have 18-wheeler that comes into our property at Dunkin'. And that comes around like noon, and they park it on the side where the other parking lots are. And we have no issue with the drive-throughs or anything.
Yes, that's now because there's nothing there. It's an empty lot, but you're proposing a structure that's going to have retail space where it's going to have consumers parking their vehicles along the parking spots that you have. And you're anticipating, you just testify that you have a trailer that comes in at noon for your location, and then you're going to have trailers possibly coming in for the proposed business at the new location. Where are all these vehicles going to fit in?
I mean, where the Dunkin' trailer comes in, it's right now they park in the parking where the Dunkin' is. They don't park anywhere on the right-hand side.
Okay, that's fine, but, you know, 2 trailers, consumers, you know, that's a lot of vehicles in a limited space. That's what I'm trying to get a sense of.
So if I can suggest this as well, part of our testimony was off-peak hours. And for a Dunkin', off-peak hours is perhaps noon. The peak hours are earlier in the morning. Here, if the retail shops are not going to be open, again, the scenario that we outlined was 6 a.m. There's almost no retail shops that are open at 6 a.m. The QSR operator, the restaurant on the end, they have the highest degree of motivation to make sure that they're loading at a time that's not disrupting their customer flow. So I would suggest the Dunkin' and what Mr. Patel testified to in the hours is not necessarily illustrative of the hours that we would have here. When the loading would occur, very likely has no bearing whatsoever on when the retail is operational, and then it's just coordinating as part of the restaurant operation to make sure that the loading is not done at a time that would interfere with the traffic flow.
my last question. What type of security features are you going to be able to provide for that access way to the drive-through? Because I see this looks like a tree line there. So if you can speak to that, that would be great.
Are you referring to this area, sir?
Yes, that is correct.
Yeah. Again, this is area for the Royal Farms, and there is a drive valve which leads to the Royal Farms currently. We are proposing some, again, trees and shrubs in this area. Again, landscaping has not been designed yet for land development, but we will be including that. There is no, we're not proposing any, again, are you worried about the security part between the drive-through and the drive aisle?
Yeah, like cameras.
Yeah, we will have the cameras in the back as well, and typically all these PA system has a camera built into it. So that's certainly going to be there. We'll have lighting, which will be proposed along this back of the drive-through as well. So in the evening hours, in the winter times, we will have the lights so that people using the drive-through feel safe.
Thank you.
Thank you.
I just have a quick question. So the businesses, so right now, that's a parking lot. And the businesses that surround the proposed area, do they not use portions of that parking lot? And where, there are businesses over there, aren't there?
Let me just go back to the existing condition plan. So as you can see, the businesses you're referring to, maybe these areas, they have their own parking area. And Royal Farms has their own parking area, so does Dunkin'. And PA Driving Center also has their own parking area. So this parking is pretty much empty. I've been there multiple times and I've not seen it. And Mr. Patel can confirm because he's always there.
And it's always vacant.
Okay. So you're saying it's always vacant? So it's not going to impact any kind of traffic going through there? I guess I normally see the police or somebody parked up over there. Am I talking about the right place?
Yes,
Okay. And then,
in the blue.
correct, in the blue. So, and then the area to the right of the blue, I guess if I'm going behind Royal Farms, in the area to the right of the blue, right here, who parks there?
Again, there are a bunch of users here. Signorama is one of them. There's a travel company, and I have some sign exhibit. Maybe I can show it to you, and that will show you. Yeah. So again, there is a furniture place at the corner at this location. There is a Signorama, which is in the middle. Eastern Coach Company is in this location, and there is an ice cream shop, which is at this corner. So these are the uses which uses this area. Again, as you can see, even that parking area is not even full.
Okay, and then is USM still there?
That's in the.
That's the big,
Where the driving center is?
It's right
They're
here.
on top of that.
It's in
okay.
this area.
And so where do their employees park? Underneath, or they
They have
park?
a whole
The parking
lot
garage
right
in the
there,
back.
Parking garage.
Okay. And then, and maybe I'm wrong, it looked like going down Johnson Highway sometimes, it looks like some of the businesses on the opposite side of the street tell the people to park over across the street in the parking lot. Is that not the case?
What was it?
Across the street, so there are businesses, there are retail businesses across the street. They are not, again, they're not supposed to be parking on this side. They're also not part of municipality of Norristown that's on the other side.
They have a few parkings on their lots anyway.
Okay. That's all I have.
We'll go to the municipality.
All right. The The subject property is located in the commercial retail district. The applicant proposes to utilize the property as commercial space containing retail and restaurant uses.
Thank you. We'll open it up for public comment. Anybody from the public want to testify either in favor or opposition of the application?
It's Jillian, Jillian. Last name is T as in Tango, K-A-C-H-U-K. It's Kachuk.
You swear affirm testimony about to give the truth, the whole truth, and nothing but the truth?
Absolutely, yes, sir. Yep. What you're thinking of is the zoo has the shuttle. So I'm not opposed to retail and especially green space. Who doesn't like a green space? The zoo does bring in a lot of revenue. I don't know what the agreement is, because that's where all the shuttle comes and all, and they park. Because I definitely have parked in an empty lot too, and then stop, get a Dunkin' Donuts, and then I usually just walk sometimes too. But that's what you're thinking of. That's all. Thank you.
Anybody else from the public want to provide any opposition or for the application? If not, we'll, okay.
State employee for you.
David Wolf,
Spell
W-O-L-F-F.
Swear or affirm testimony about to give the truth, the whole truth, and nothing but the truth?
Yes. And just a simple commentary, we have ourselves a gentleman here who's trying to improve the area, provide additional retail, and also, let's call it as is here for a moment, tax revenue. So from that particular standpoint, I would like to, if nothing else, endorse this project.
Thank you. Anybody else from the public want to provide any public comment? Seeing none, we'll close public comment. Any summation that you want to offer the board? I'm sorry.
Mr. Chairman. I did have a question. I realized we didn't touch on the lighting or the sign. How is it going to be illuminated, or, I mean, lumens is the light? Where is it facing?
Again, we are in process of designing the whole shopping center, but lights are going to be along the parking to make sure the parking is properly lit, as well as there may be few lights on the building, but mainly through the parking lot lights, which will be put.
I'm sorry, I'm referring to the signage.
Oh.
On the building or the pylon?
The one that's going to be on that corner that you.
Oh, the pylon, the monument sign?
Yeah.
Yeah, it will be lit as permitted by the ordinance.
So based on the young lady's comment, has there been some sort of agreement made with the zoo shuttle pickup being there?
No.
And you're there every day, so I know you know that it's there, so.
Yeah, I mean, they use it right now, but we have no agreement with them.
But you don't own that, right? You don't own that area.
No, we're there, I mean, right now they're using as a shuttle service.
Mhm.
They have a tent, they put up the tent, and they just use it right now, but we have no agreement with them.
I think you're missing my question. You don't have an agreement with them, but somebody evidently has an agreement with them. The municipality must have an agreement with them. They can't just set up a tent. They have to have some sort of permit to set it up there. So have you had a discussion with them as far as what your plans are?
Are you asking if Mr. Patel owns the property that we're discussing this evening?
Yeah.
He does.
So he owns the whole parking lot?
Yes.
So I can't imagine that the zoo would just set up a shuttle. They have to have an agreement with someone.
Not with me.
I can't comment on that, but I can say that Mr. Patel owns both the Duncan parcel and the Royal Farms and the 1.9 acres we're here to discuss this evening.
Okay, thank you.
Just one question about that pylon sign on the corner. What are the dimensions of that, and like what will it say? Like what is?
So you can see on the top of that, the freestanding monument sign, and I apologize for the small print. We have it listed as, I think it's 9 feet, 6 inches in width. And you have the base at the bottom, which is a sort of stone veneer, and then you have, on the left, you'll have the 3 tenants, and on the right, you'll have the 3 tenants. That is going to be 6 square feet, 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 6 square feet. So the total amount of space for the signage, and it's probably better here, is 36 square feet, and we are trying to minimize the amount of space that's provided. We're not making it a giant freestanding sign. It's just 6 square feet for each of the businesses.
I'm trying to get my bearings. Is that where the tall Royal Farm sign is, or is that it's on the other side? It's on the right.
I think you have a very good memory. That Royal Farm sign is at this location.
I got you. Okay. We've had a long history with that property, so I know there's signs all over the place. But okay, now I got it.
I'll make a motion to close the hearing.
I'll second the motion.
Aye, aye.
All in favor? Any opposed? Motion carries. Is there a decision on the application?
I'll make a motion that we grant the variance for case 28-26 for the requested relief.
Is there a second on the motion? Second. All in favor?
Aye.
Any opposed? Motion carries. Our application is granted.
Thank you very much. Have a great night.
We're going to see if anybody wants to continue, because we're only going to get this guy started and finished. Oh, up to you.
I can keep this brief. It's an easy one.
Sorry, I just want to, don't mind, put till next month, if that's possible. Yeah,
It'll be, I'll send you a letter to confirm. That's 30-26.
Thank you, Board.
All right, may I make a brief offer of proof here?
Just give me 1 second. Mr. Dawson?
Yes, I'm sorry. Good evening. May I make a request for continuance?
Okay. So again, it'll be next month, July 28th?
Yes, sir.
All right.
That's fine.
Thank you.
All right, thank you.
31-26, requesting a continuance.
Or Beth? Okay, yeah, July 28th, again, I'll confirm in writing. Thank you. Okay. 29-26, 29-26.
Patrick Blair, B-L-A-I-R. And from Timmy Knox, I represent the applicant that's seeking a variance for the, essentially for a failure to pay for a rental license for over a year, which my client does not deny. He changed property groups about the time that the non-payment occurred, and he thinks that either the renewal was sent to the prior property management group or the current property management group didn't understand what was being sent to them. And I would like to offer an offer of proof in regards to the request for variance.
Let's put some information on the record. This is 2926. Applicant is Joshua Drebs. 2309 3 Mile Run Road, Perkins CPA, 18944. Property location is 550 Cone Street, Norristown, PA. The applicant and the owner are the same. And the applicant is requesting relief from section 320, 292A, 2A3 to permit the use of an abandoned duplex in the R2 district.
Thank you. So the first point I would like to make is this property wasn't actually abandoned, and you'll see in the offer of proof I provided, he had leases in place, and during the year that this property was allegedly abandoned, so that would be A1. A1 is the original lease, A2 is an extension for Unit 1. A3 is the second lease, and A4 is the extension for the second lease, that would be Unit 2. Both of the extensions are within the year period prior to, receiving the notice of abandoning the property. And moreover, both tenants went month to month after the extension. I don't have paperwork for that, but the paperwork does establish it's within 365 days. So our first point is the property wasn't actually abandoned during the year that the license was not being renewed. In addition, as to the issue of the duplex, my client will testify consistent with the fact that he bought it as a duplex. It was his understanding had always been a duplex. My client didn't create the duplex. When he bought it with the understanding it was a duplex. It would not have been a financially viable purchase for him if it wasn't a duplex that allowed 2 renters. That would be Unit 1 and Unit 2. And then during the time that he's owned it, he's always used it as a duplex. So that would in terms of the time to show renters were actually in place during the alleged abandonment, that's A1, A2, A3, and A4. A5 is the prior property management group that did financial background on these proposed tenants. And this was the one that likely received the renewal applications for rental license, did not advise the new property management group that it was due. A6 is some photos my client provided as part of the application for the variance here today. I guess the best one would be exhibit number 9. It does show on the left-hand side the 2 different, I'm assuming it's, well, actually, I don't know what it is, but it's the 2 separate meters, I believe, for the 2 units in the building. But A7 has a much better set of photographs that my client provided subsequent to the application that we're here today. So the first page establishes the 2 units. Again, we have the 2 mechanicals there on the second page, with the 2 mailboxes on the third page. Fourth page is consistent with what I talked about. Fifth page is the 2 heating units for the duplex. Next page establishes multiple trash cans for the duplex. Next page, the 2 different mailboxes. Next page is a close-up of the 2 mechanicals I've been talking about. And then second to last page is kind of a layout of where the breakout of the duplex, one being on the first floor, and then on the right there you'll see the stairway to the second floor, and then the last page being the 2 water heaters again. Essentially, what we're here to hopefully establish is that this has always been a duplex. It was bought as a duplex, it was maintained as a duplex, there was renters in place during the time of the alleged abandonment, and as far as we know, there was no inspection as required by 320-292 from the Norristown Codes Department. I've never seen that. So my client would respectfully request that he be granted a variance for the non-conforming use of the duplex, and he's obviously willing to pay any back fees related to the late renewal. And I would just briefly have my client come up to confirm the summary I provided.
Joshua Drevis.
Swear or affirm testimony about the case is the truth, the whole truth, and nothing but the truth?
I do.
Josh, did you hear my testimony or
Yes.
my summary to the board earlier? And if I were to ask you any questions today, would it be consistent with the summary I provided to the board?
Yes.
Was everything I provided to the board true and accurate representation of your ownership of 550 Cone Street?
Yes.
Was there anything I left out or missed that you'd like to add to the board?
No, I don't believe so. That was it.
A couple quick questions. When did you acquire the property?
I believe it was in 2019.
2019. And you acquired it with tenants? With or without tenants?
Without tenants.
Without tenants. So subsequent to 2019, have you paid rental licenses? Have you paid rental licenses since you acquired the property in 2019?
Yes, up until 2023.
Up until 2023. And in 2023, were there still tenants in the property?
Yes.
Any particular reason why you didn't pay the rental license?
I didn't receive the application, I guess, for the rental license. We believe that they went to the other property management company. I'd
Got it.
switched property management companies.
And the property today, you didn't make any modifications to the property? You purchased it as it's constructed today?
Purchased it as a duplex, it's still a duplex today, yes. Just, yeah.
And you're agreeable to pay any back licenses if, or grants relief? Okay.
Yes, sir.
Are you getting ready to sell the property, or how did you end
Yes,
up
ma'am.
here? Okay.
Yes, that's how I found out about this. I didn't know it was not paid.
And so the sale is contingent? Sorry about that.
No
Like a
problem.
dog.
Yeah, the answer to that is, yes, I believe it is contingent. That's why I'm here today, to be granted this, yes.
Was it your intention to abandon the use of a duplex?
Was it my intention to?
Abandon the duplex use?
No.
Thank you.
Yes.
Any other questions from the board? Any summation or anything else you want to tell the board?
No, that's it. That's it for the board. Thank you.
Got it. Is there a motion to close the hearing for this application? Is there a second?
Second.
All in favor?
Aye.
Any opposed? Motion carries. Oh, let's do public comment. For the record, anybody from the public want to testify either in favor or opposition of the application? Seeing none, is there a decision on the application? Oh, let's go to the municipality. Sorry, trying to wrap this up.
Thank you, Chairman. The subject property is in the R2 residential district and is currently configured as a duplex. The rental license for the property has been abandoned with the last valid rental license issued in 2022. Municipal records indicate that rental licenses were maintained for the property as early as 2008.
Thank you. With that said, does somebody want to make another motion to close and a motion on the application?
Second.
So we have a motion to close, we have a second.
All in favor?
Aye. Is there, somebody want to make a motion for a decision on the application?
I make a motion to approve case 29-26 contingent on paying back all outstanding rental license fees.
Is there a second?
I'll second.
All in favor?
Aye.
Any opposed? Motion carries. Is there a motion to close this evening's hearing? And a second?
Second.
All in favor? Aye. Any opposed? Motion carries.
Thank you so much.
Great, thank you.
And have a nice night. Thank you for allowing us to get it in at the end.
Yes, thank you.